Today was a very historic day. It's the occasion of the Belfast Moot final, but it's the first ever such Moot competition between Ulster and Queen's, and presided over by a 5-court Supreme Court bench, which is something that most advocates will never have to face in their professional lives. The benefits to the students are that they are in a simulated, practical, clinical type environment. So they are put in the pressure cooker situation that lawyers would be in arguing an appellate case before the Supreme Court. And it's part of our kind of growing clinical trend in the law school to move beyond the books into a sort of a practical type of legal educational model where students are confronted with some of the difficulties, the intricacies, and the nuances of law. And that's one of the things that is most beneficial to students from mooting.
It's the first time the court has been to Belfast, and it's the first time we've had a moot as part of the programme. So this is very special, and it's a local derby. We've got 2 universities locally competing against each other, and we have 5 justices doing it, which must be absolutely terrifying. Well, mooting is an important part of what we do at the Supreme Court, and we have a programme of 12 moots during the year, and universities can apply to be part of that programme, and it's one of our components about accessibility and demystifying, and also giving students an opportunity to practice their oratory and to get some feedback from the justice, because it's not just a question of winning or losing the moot. You also get some feedback from the justice about how your advocacy skills have been put across.
We helped the students prepare for today. We took them through their written submissions and also their oral submissions. We acted as judges on the bench and took them through questions and intervention from the bench and to see how they dealt with this. We also posed quite difficult questions for them to get them thinking, just in case something untoward came up so that they could deal with all these problems.
Well, there are, I suppose, 2 main strands of benefits to what we've been doing today. And the first strand really is an overarching benefit of being able to appear in front of the UK Supreme Court. And the second strand of benefits then comes in the sense of our own personal development, being able to present a case, research a case and build it in front of people of the calibre of Lady Hale, Lady Black, Lord Mance, and receive the commentary and I suppose the inquisition that then comes from judges of that calibre. So that's a hugely fulfilling experience that will be really, really beneficial to all of us as we embark on our future careers as both solicitors and barristers. It's been somewhat of a whirlwind preparing for today. We've really only had the space of 3 weeks to get our argument prepared. Really it was about spending the late nights researching cases and putting our argument together, relying on precedent, and really about getting our team's presentation skills up to scratch before appearing in front of their lordships and their ladyships. I suppose I feel a mix of emotions especially after the verdict. Ultimately it was a split decision. We won the points of law, but our opponents won the argument overall, which is simply how these things go. But overall I think that it's a fantastic experience. We'll remember this for certainly the rest of our careers, if not our lives, and absolutely a very rewarding experience. I'm very grateful to have had it and very grateful for the support that we received from Ulster University.